Good evening. And when we have the Harindranath, a senior advocate from Kerala High Court and a former professor in the National Judicial Academy in Bhopal, you are quite sure that the insights being given by him would be appreciated by one and all. We have been debating and discussing as a student of law that what are the contractual rights and obligations relating to the immovable property under the section 40 of the Transfer of Property Act, the rights of a promise. This topic we took so that the students who are studying for the judiciary or ADAs, etc., coupled with the students of law and professionals, it becomes an interplay for everyone. And we are so glad that after quite a lot of time, Mr. Harindranath has agreed to take a session. Over to you, sir.
Thank you, Mr. Vikas. And this topic is not something which is always discussed. And very rarely, in fact, even I have found that in courts of law, the substantive law regarding the obligations under a contract for sale of immovable property is discussed. Now, before going into these aspects, I am to tell you that I am, because section 40, first and second part, deals with the positive and negative covenants. And I am not really going into those jurisprudential aspects of what a positive covenant is, what is negative covenant is, because it is more academic. What is interesting for practitioners is what happens when you sign an agreement for sale to purchase an immovable property. What are your rights under the substantive law? And besides filing a suit, of course, there is a specific relief act, which is the aid to enforce a contract, but the contract for sale of immovable property. But insofar as the rights and obligations are concerned, it is laid down in Transfer of Property Act, so far as immovable property is concerned. Of course, we have decisions. Now, what centers around the sale of immovable property are the questions of whether party was ready and willing to perform as part of the contract, whether there was readiness, whether there was willingness. Then the questions much debated is whether the time is of essence of the contract, and in a sale of immovable property, whether stipulations regarding performance of a contract on a particular date makes the time the essence of the contract. These matters also I don't intend to discuss, because we always have so many discussions, many decisions on this point. So what would be more ideal is to go to the basics in the sense that the Transfer of Property Act itself. Now, I will straight away come to section 54 of the TP Act, because 54 deals with the sale of immovable property. Now, if you read section 54, you will understand that contract of sale of immovable property is a contract that a sale of such property shall take place on the terms settled between the parties. That is the definition contained in section 54. But then you will understand that merely because you hold an agreement for sale, it does not by itself create any right in the immovable property. So now that is what is defined in section 54. Now, that second part, the third part of the, after defining sale as a transfer of ownership in exchange for price paid or promised, or part paid or part promised. That is what is sale. It is not necessary that you should pay the entire consideration. There can be agreements where the entire sale price is paid. There can be agreement for sale where party, sale itself where party promises to pay the entire sale consideration, or it is part paid or part performed, in the sense that part of the property is parted away by the seller. So the sale is defined as a transfer of ownership in exchange for a price paid or promise or part paid. Now the second part deals with how it is made. Of course, if it is above 100 rupees, then you know that the it has to be by a registered instrument as contemplated in the Registration Act. Now we come to the last part, the contract for sale. I have already read out that a contract for sale of immovable property is a contract that a sale of such property shall take place on terms settled between the parties. Parties settle the terms, and then the sale of such property takes place in accordance with the terms settled by the parties. That is what is understood by contract for sale. Now, this third part contains another subpart that says it does not of itself create any interest in or charge on such property. This is very important. You enter into an agreement for sale and say that I will purchase the property for a consideration. Let's say some amount is mentioned in the agreement for sale. But then the Transfer of Property Act section 54 says that it does not create by itself any interest in or charge on such property. Only when you file a suit and you are entitled, if there is specific performance is not granted, now then you are entitled to get your advance amount paid by you returned. In such a case, there is a charge on the property as contemplated under section 55. Now, I am not going into those aspects also because the time is short, and therefore I shall only go into the question of what the silence in section 54. There is a silence in section 54 as to what are the rights of a person who has agreed to purchase the transfer of, immovable property. Now, if you enter into a contract for sale and pay some consideration to the seller, then the section 54's last part says it does not by itself create any right in the immovable property. Then what is the right you have? Once you then execute an agreement for sale, that we find in section 40. That is the subject which I would discuss today, but not the other part of section 40, because section 40 contains two parts. First part is where for the more beneficial enjoyment of his own immovable property, the third person has independently of any interest in the immovable property of another or an easement thereon, the right to restrain the enjoyment in a particular manner of the latter property. That is a negative covenant. Now, easement, are restrictions on rights of property. You may have a right to use another person's property as a way. You can have an easement for light, for passage of air, so many things, for water, all these things. That is a restriction on the right, which you will find in section 7 of the Easements Act. You will find the definition for what are natural rights, and that section says easements are restrictions on natural rights. Now, besides the easement, third person may independently have any interest in the immovable property of another. There will be restrictive covenants so far as buildings are concerned. Don't build a building beyond a certain height. And these such matters are negative covenants, which also is not subject matter of our discussion today. Because what we are more concerned, what comes before the court many a times is the second part of section 40, not discussed very much in courts of law. These contentions are never advanced. Now, you understand, see, the second part of section 40 speaks of an obligation arising out of a contract for sale of immovable property. Now, many a times you find that you enter into an agreement for sale to purchase a particular property. There will be another agreement for sale, which a unscrupulous seller would have made with another party. Then there will be two agreements for sale, one in your favor, one in favor of the other person. And sometimes some of these two agreements will, agreement holders will say that I have got a right to purchase the property. Sometimes the seller, being the owner of the property, may enter into an agreement and then sell the property itself by a registered deed. You may not know about this. You may have obtained an agreement for sale prior to the registered document. So then what are your rights in such a case? This also is a difficult thing. And then what happens in a suit when you file such a suit to enforce your obligation arising out of the contract? When there is already an agreement, when there is already a registered sale deed in favor of a third party, that too after execution of the agreement for sale in your favor. So these are three situations which I have, narrated to you. First one is there is an agreement for sale, there is another agreement for sale, two persons. Then A has an agreement for sale, and then immediately after that, the seller registers a sale deed in favor of a third party. What will be the rights and obligations of the party who holds an agreement for sale? Lastly, in a suit, what are the rights of a person who has already obtained a registered sale deed? Now, this is what is dealt with under section 40 of the TP Act, which says burden of obligation imposing restriction on use of land. That is the first part. Or second part, in bold letters you will find in many commentaries. Or of obligation annexed to ownership, but not amounting to interest or easement. First part is, does not create any interest in the immovable property. There is an obligation annexed to the ownership, but it does not create an interest in the property, and it is neither an easement. Of course, easement is an interest in the immovable property of another person. Now, this is what an agreement holder has. The beginning of second part. What is it? It is an obligation arising out of a contract and annexed to the ownership of immovable property, but not amounting to an interest therein or easement therein. That is how the section has been worded, very carefully worded. Where a third person is entitled to the benefit of an obligation arising out of a contract and annexed to the ownership of immovable property, but not amounting to an interest therein or easement therein. An easement and an interest in immovable property created by a deed can be enforced against anybody. No doubt about it. But if it is not an interest in therein or an easement thereon, it is just an obligation. That is, you give some money to the owner of the land, write an agreement to purchase, or even orally, you write an agreement to purchase the immovable property. Nothing more. You execute an agreement, and then the seller has an obligation arising out of a contract annexed to the ownership of immovable property to sell the property. That is an obligation of the seller. The question is how far you can enforce that. Now, the second part of the second part of this, the second para of the second part, that is obligation annexed to the ownership but not amounting to an interest or easement. The second para defines what is the extent of such right, against whom it can be enforced. Now, this is what it says. Such right or obligation may be enforced against a transferee with notice for thereof. Now, if you have an agreement for sale in your favor, another person has also an agreement for sale in his favor with the owner of the immovable property. And if the second person is aware that there was a contract between you and the owner of the property, then this obligation, that is in a specific performance suit, it can be enforced against the person who has notice thereof of the first agreement. I will make it clear once more. There are two agreements. First agreement is an agreement for sale of immovable property. That is known to the second agreement holder. Therefore, if a suit for specific performance of contract is filed by the first agreement holder, if the second person has notice of the first agreement, it can be enforced against him. This is the meaning of the section. But then it says there is a rider, but not against a transferee for consideration and without notice of the right or obligation, nor against such property in his hands. Now, there is a transferee for consideration. Now, when does this transfer happen? The transfer happens when there is a sale deed. So it cannot be enforced. Even if there is a sale deed, the obligation can be enforced against a person who has that notice of that. But if the transferee for consideration is unaware of the first agreement, it cannot be enforced against him. I think there can be no doubt on this aspect. There are two conditions are necessary. That is, there should be consideration for the second transfer, and the transferee must not have had notice of the first agreement for sale. First agreement for sale. So I think things are clear. So if you have to get back the purchase money, it cannot be enforced against such a person. Now, the illustration gives you a clear idea. A contracts to sell in the TP Act. A contracts to sell Sultanpur to B. While the contract is still in force, he sells Sultanpur to C, who has notice of the contract. A may enforce the contract against C to the same extent as against A, because C has notice of the transfer. Suppose he does not have any notice, it can't be. Suppose it is a gratuitous transfer. That is why the word uses transferee for consideration. Before that, it uses or a gratuitous transferee of the property. If it is a gratuitous transferee, for instance, a gift is given on the basis of love and affection, it can be enforced against a donee. If there is an agreement for sale, it can be enforced against a donee. But it can't be enforced against a person who has purchased the property if he had no notice of the agreement for sale. That is why the word used is consideration. Now, this decisions, this aspect is given rise to various litigations, and you should note that this is a contractual obligation. Many a times, this matter is not gone into or never agitated before the court. Now there are preemption contracts also, which, if time permits, I will come to that also, because these matters Then, now let us look at the attachment part of it. Now, property is attached, but the substantive law is contained in section 40. Previously, before the amendment to the section 64 of the CPC, if there is an agreement in favor of a person prior to the attachment, that would not bind the agreement holder, because if the subsequent conveyance, if it is in pursuance of an agreement for sale under the attachment, the obligation created by a contract for sale will prevail. That is in Harindranath versus Shantakumar, the Calcutta High Court, and following that, many other high courts held that this equitable right would prevail over section 64. Now you know that section 64 has been amended. Section 64 of the CPC has been amended. Now, this will not say unless so mere agreement for sale, because why it was amended is many attachments for sale are frustrated because of this kind of an agreement created. It is easy to create an agreement for sale, as you know. If there is no registration, you can simply create an agreement for sale. That is why, you know, section 53A was also amended. This 53A would be put into as a defense in a suit filed by a genuine transferee, and then they will say that they will create an agreement, a written agreement prior to the with a predated agreement, and say that he is put in possession in pursuance of the agreement for sale, and then the possession can be protected under 53A. It can be used as a shield and a sword. That has been clarified by the Supreme Court. But now, after the amendment to the Registration Act and the section 53A, now there should be a registered deed. So this, to a great extent, prevents fraudulent transfers and persons putting up a defense of 53A part performance in suits. That is why 64 has been amended. So therefore, now we come back to the subtle nuances of section 40 of the TP Act. Now, the notice of contractual obligation, that should be there. So what happens is, anybody can contend that I had no notice of the sale deed. But then notice can be constructive notice. Now, this obligation may be a constructive notice also. If there is a registered agreement, registered sale deed, then the notice is it is presumed, or there is something what is called constructive notice. Party is presumed to know that if there is a registered sale deed, is presumed to know the factum of registration. But if the agreement for sale is on a simple paper, stamp paper, people are not expected to know that. Then what happens in such cases? It can only be enforced if there is telltale evidence that the subsequent purchaser who had executed had a clear notice of the agreement for sale. That is not impossible, but it can be. Now we come back to some of the decisions of the Supreme Court on this point, on section 40. I hope the earlier decisions, one of the earliest decisions is contained in that is by Justice Chinnappa Reddy, Sarkaria and Chinnappa Reddy, division bench of the Supreme Court, 1983 SEC 4545 by Dosabai versus Mathurdas Govindas. I'll just type in the chat box. I shall just type the decision for your convenience. Sorry. (1983) SEC 545. Now, their lordships had gone into the questions of both Section 54 and Section 40 of the Contract Act. Section 54 and Section 40 of the Contract that deals with the their lordships also went into Section 12A and 16 of the Specific Relief Act. We are, for our discussion, now not concerned with the Section 12 and 16. We will just confine our discussion to 54 and 40 because that is the subject matter which we are discussing today. Now, you see, there is the English doctrine of equitable estate. But then English doctrine of conversion of reality into personality cannot be lifted from English because it is relevant to English soil and it cannot be transplanted into statute-bound Indian law. Because as you know, the English courts have this equity jurisprudence. And many a times in the Indian statutes, the English equity has taken statutory forms. But they cannot be lifted otherwise when there is a clear-cut statutory provisions in the Act. Now, let us go to the facts of this case. That is, the appellant, Dosabai, had obtained two plots of land. A tenant was actually in possession of the land. And then, then there was an agreement for sale. And now, when we come to paragraph 7, this is what their lordships observed. We do not wish to go in any detail into the question whether the English equitable doctrine of conversion of reality into personality is applicable in India. However, we do wish to say that the English doctrine of conversion of reality cannot be bodily lifted from its native English soil and transplanted in a statute-bound Indian law. Because our law, basically, we have got myriad of statutes. And they say, the Tennyson in his famous poetry, Locksley, I just forgot the name of the book. He says, godless myriad of precedents, the wilderness of single instances. So this in this code, you are tied this myriad of precedents. That is what Tennyson says. But so far as our Indian law is concerned, we have got statutes. We are actually entangled in statutes. They are entangled in more equity jurisprudence and precedents. But we are more entangled in statutes these days because every now and then you can find that there is a statute passed by either the parliament or the statute passed by the state legislatures and on various subjects. And therefore, Therefore, the Supreme Court has used this is actually in 1980. Now we are in 2026. We have almost, God, I don't know, so many statutes. We all know there are so many statutes in our country. We have got 3 lists in the Constitution: central list, state list, and then the concurrent list. In all these statutes, we find laws, one encroaching into the penumbral area of another, and of course, there are well-defined rules like that enunciated in certain uh, cases where state list is made subject to the central list. The Supreme Court has invented a doctrine called doctrine of occupied field. So if the entire field is occupied by a central legislation, some decisions of the Supreme Court says that the state legislature is denuded of any power to legislate in the state list. So that is one aspect of the matter. There are 4 constitutional decisions on that point. And then there is the concurrent list. In the concurrent list, if there is a central law and a state law is there, state law which is repugnant to the central law will not prevail unless there is a presidential assent. It is sent to the president. These are all complications in our law. And we know, as Supreme Court has observed in these cases, they said that English law cannot be transplanted in a statute-bound Indian law. But we have to notice that many of the principles of English equity have taken statutory forms in India and have been incorporated in occasional provisions of various Indian statutes, such as Indian Trusts Act, Specific Relief Act, Specific Relief Act, Transfer of Property Act, and where a question of interpretation of such equity-based statutory provisions arise, we will be well justified in seeking aid from the equity source. The concept and creation of duality of ownership, legal and equitable, on the execution of an agreement to convey immovable property, as understood, sorry, as understood in England is alien to Indian law, which recognizes the owner, i.e. legal owner, that they have referred to 2 decisions of the earlier Supreme Court decisions, which is Rambaran Prasad's case and Narandas Karsandas case. The ultimate paragraph of section 54, which I have read out to you, their lordships have discussed that the ultimate paragraph of section 54 of the TP Act expressly enunciates that contract for sale of immovable property does not of itself create any interest or charge in the property. But the ultimate and penultimate paragraphs of section 40, which I have read out to you, section 40 of the Transfer of Property Act makes it clear that such a contract creates an obligation annexed to the ownership of immovable property, not amounting to an interest in the property, but which obligation may be enforced against a transferee with notice of a contract and a gratuitous transferee of a property. Thus, equitable ownership in the property recognized by equity in England is translated into Indian law as an obligation annexed to the ownership of property, not amounting to an interest in the property, but an obligation which may be enforced against the transferee with notice or a gratuitous transfer. A strong bench consisting of Chinapareddy and R.S. Sarkaria. Now, this is one of the important decisions which you have to understand, deals with this question. Now, I shall take you to another decision of the Supreme Court, which before that I will just refer to, I will take you to the Supreme Court decision, which is Ansa Gandhi versus Deep Shankar Roy, 2013. That also I think I shall be sharing it. You should type that for your advantage. In 2013, LSEC 776. This decision is by a bench of 3 judges. That is Hansa Gandhi versus Deep Shankar Roy and others. Now, in this case, I'll just take you to paragraph 15. It says, I shall read out for your advantage. It was mainly submitted by the learned counsel appearing for the subsequent bias that in absence of any registration agreement entered into between the plaintiff and developer, the subsequent buyers could not have got an opportunity to find out existence of a letter of intent or an agreement, if any, entered between the plaintiffs and the developer. According to the learned counsel, registration of a document is a notice to all persons concerned, and in the absence of registration of so-called agreement, it cannot be presumed that subsequent buyers had any knowledge with regard to the earlier transaction. The burden of proof would be on the plaintiff to establish that subsequent buyers had knowledge about the earlier transaction entered into by developer with the plaintiffs. The counsel appearing for the subsequent buyers submitted that section 4 under the Act makes it mandatory to get agreement between the purchaser and the development. Registered it, but in the instant case, there was no registration as contemplated under section 4.1 of the Act. And that is why. Now, this decision deals with mainly the question of constructive notice. Now, their lordships say that if there is a registered agreement, buyer registered agreement, there is something called which is a constructive notice. If suppose there is no registered agreement, possibly there is no way of knowing, even if you publish in the newspaper, not necessarily that you would read all these things. Nowadays, so many things are there. So, unless it can be proved, because the burden of proof is on the person who's trying to enforce the obligation arising out of the contract, to say that the subsequent registered agreement holder had notice of the earlier agreement. Now, if the first agreement was registered, obviously, there is something called constructive notice. That is what has been narrated in paragraph 15. Then paragraph 22, they make it very clear. This is how you should plead. As no averment was made by the plaintiff in their claim that subsequent buyers were not bona fide purchasers for consideration, the subsequent buyers could not have adduced any evidence to show that they were purchasers for consideration. Had such a plea been raised by the plaintiff in their pleadings, the subsequent buyers could have adduced necessary evidence to prove their case. In such cases, normally the burden of proof would lie on the plaintiff unless there is a registered agreement, so as to raise a presumption that subsequent buyers have knowledge with regard to the earlier transaction. Such burden of proof was not discharged by the plaintiff, and therefore we are of the view that the subsequent buyers were bona fide buyers for consideration. Now you see, this is very clear now. Now, unless the subsequent buyers had notice of the earlier agreement, I'm sorry, the plaintiff, that is the first buyer, if he is trying to enforce it, the subsequent buyers, it should be proved by the plaintiff that subsequent buyers had knowledge, either by positive evidence, or if there is a registered deed, you can presume that they had noticed, because constructive notice applies. Otherwise, it cannot be said that that the agreement for sale could be enforced against the person. Now, there is an interesting decision by the Kerala High Court that is reported in. I don't know whether you will get it. Of course, I've taken out the AAR citation, which is AAR 1990 Kerala. This is by Justice Padmanabhan. It's a single bench decision. But Justice Padmanabhan was one of our finest civil judges. So he has gone into all these questions. He has also gone into the question of the applicability of list pendants in the specific performance suit. Then he goes at paragraph 11 and just read out paragraph 11. It is clear from ultimate paragraphs of section 54 and TP Act that 40 of the TP Act that a contract for sale of immovable property, though does not by itself create any interest or charge in such property, it creates an obligation arising out of a contract and annexed to immovable property, not amounting to an interest in property. Such obligation could be enforced against a transferee with notice. The equitable ownership in the property recognized by equity in England is thus translated into Indian law as an obligation annexed to ownership of property, not amounting to an interest in the property, but an obligation which may be enforced against a transferee with notice or a gratuitous transferee. The concept and creation of duality of ownership, legal and equitable, on execution of an agreement for conveying immovable property, as understood in English law, is alien to Indian law. This is what the Kerala High Court has held. Now, you see, this is very. Now, there are now one more decision by Justice S.P. Sinha. When I was in the National Judicial Academy, Justice S.P. Sinha was very frequently used to come there. He basically was a scholar, and he was the sought after resource person. So it is his decision by Sinha and Justice Markanday Kadju. It was reported in 2007, 15 SCC 174. It is the name of the decision is Janardhan Prasad versus Ramdas. Now, this decision, the lordships have referred to in paragraph 14. I am not reading out the paragraph 14 entirely, but what they have said in this is that a person is said to have notice of a fact when he actually knows that, or when but willful abstention from inquiry or search, which he ought to have made, or gross negligence, he would have known it. So far as registration is concerned, you apply for an encumbrance certificate. You note in the encumbrance certificate that there is an encumbrance on the property. So then it is easy for you to come to know whether there is an encumbrance or not. So that is the importance of the registered document. That is why if you are grossly negligent, you don't go to the registrar's office, attempt to get an encumbrance certificate, then you are grossly negligent in purchasing a property. That is what that has been clearly explained by Justice S.B. Sinha. He has referred to section 3 of the TP Act, which deals with constructive notice. The explanation 1.3. Because of paucity of time, I don't want to read the entire thing. So now, then there is one another aspect to this, which is the last question, which I want to be. In such a suit, is it necessary for, if a suit is filed for suit is filed, is it necessary Paragraph 87. I'm sorry, that is not the judgment. The last decision which I want to cite is 24 3 SCC 232. You may go through and read this decision also. I think that would be ideal. Now, it's a decision by Sanjay Karol, which I have just pointed out to you, which it is in paragraph 20. Paragraph 20. The sale is not void, but only voidable at the option of the earlier contract. That is what is being held in this decision. Now, there is another question which is dealt with in the decision Maharaj Singh versus currency, which is it's a later decision of our Supreme Court, which is in 2024. 2024 8 SCC. 2024 8 SCC. 8 SCC. Eight SCC 83. So in this case, you should just read out paragraph 20, paragraph 22. This is an important aspect of this kind of suits which come to set, which are filed to set aside as sale deed, or another agreement holder files a suit for specific performance without impeding the person who has obtained title by a registered sale deed. And these kind of subtle tricks are played in courts with all sorts of obnoxious praise. But then lawyers, who are conscientious and studious will be able to look into these matters and defend it properly. Now, paragraph 22, I'll just, there's a bench of two honorable judges rendered. Unfortunately, the attention of the bench was not invited to the binding precedent in the form of a decision of a larger bench in Durga Prasad. Hence, the decision in Vijay Bharati is not a binding precedent. Therefore, there was no requirement to make a prayer in the plaint for cancellation or setting aside subsequent sales. Now, suppose there is a suit, there is a subsequent sale, and if suppose there is the subsequent purchaser had notice, then is it necessary to make a prayer for cancellation or setting aside the subsequent sale? Cancellation comes under Section 31 of the Specific Relief Act. Their lordships went into this question. They said that a larger bench in Durga Prasad, that is reported in 1953 to SCC 509, had held that it was not necessary in the plain for a there need not be a prayer for cancellation or setting aside the subsequent sale deeds. Then their lordship said that Vijay Bharati, which held otherwise, that is 2018-11 SCC 761, is not a correct decision. So, because that is of a smaller bench. Their lordships in paragraph 24 said, in view of clause 9, clause B of section 19, the defendants who are claiming under sale deeds executed after execution of the suit agreement can be subjected to a decree of specific performance, and the suit agreement can be enforced specifically against such defendants unless they are bona fide purchasers without notice of the original contract. When in a given case, the defendants who are subsequent purchasers fail to prove that they entered into the sale deed in good faith and without notice of such agreement, in view of section 19, a decree for specific performance can be passed against such defendants. Therefore, in such a case, there is no necessity to pray for cancellation of the subsequent sale deeds. So this is the question which their lordships have answered. Now, with this, I think it's almost 6:55. I will close the discussion for the current. There are a lot of matters which we have to discuss, but then there is a paucity of time. Therefore, I thank you all. Today evening, you have been very patiently listening. You're around 1 hour. So thank you, Mr. Vikas Chadra, for giving me this opportunity. Thank you.
It's always a pleasure hearing you. Just hold on. One has praised Mr. Satish Kumar. It's a good session. One is there a distinction between an obligation annexed to ownership and an easement or covenant?
There is obviously a difference because easement runs with the property. This does not run with the property. It's only an obligation arising out of a contract. Easements are right an interest in the immovable property. Because if there is an easement, it is a hereditament, it will go to the because in the case of an easement, there is a person who's having an interest in another person's immovable property. So that is what is known as easement. You have under Section 4 of the Easements Act, there should be a dominant tenement and a servient tenement. The owner of the dominant tenement is not the owner of the owner of the dominant tenement has an interest in the servient tenement, that is another's property, to use it in a particular manner, so that is what is called easement. If the dominant owner sells a property, whether with or without notice, easement will run with the property. It is called a hereditament. The person who inherits that is also bound by it. You may go through Section 4 and 7 of the Easements Act and also the Limitation Act for these purposes. Thank you.
Yes. And whether a transferee for a value without notice can defeat the rights of a promisee.
Value without notice. Obviously, if there is a registered sale deed in his favor, the person, the first agreement holder is not entitled to enforce the obligation against a person without notice. If it is a sale for consideration, that is what all these decisions are made. Of course, if he has notice, the things are different.
Though you have dealt with it, the last question, can an agreement to sale create enforceable obligations under section 40 of the TPA?
Agreement for sale does create an obligation arising out of an agreement for sale of immovable property, which can be enforced only against a person with notice of the prior obligation. And if it is for valuable consideration, the sale in his favor is for valuable consideration, not a gratuitous one. There is a gift, even if he had no notice, it is of no use.
Thank you. And on Thursday, this time we will be doing a session on implementation is incomplete in the absence of rules and protocols under BNSS. This is by Dr. KP Singh, a former DGP in Haryana. So do join us on Thursday at 6 p.m. And thank you, Mr. Harindranath. We are all grateful to you. Thank you.
Thank you very much.